business disputes I see have one thing in common. They start with a badly drafted contract. Hi, I'm Babs. I'm one of the founding partners of Jameson Law, and I'm a UK commercial and corporate solicitor. In today's video, I'm going to walk you through the key things that businesses should look for when drafting and negotiating client contracts. Now, I know contracts aren't the most exciting thing in the world, but they're more than just paperwork. They're your safety net. They protect your cash flow, they limit your risks, and they give you leverage when things don't go as you've planned. By the end of this video, you'll know the 7 most important areas to focus on, some common mistakes I see all the time, and practical tips you can be using straight away to strengthen your contracts. So let's get into it. So why do contracts matter? Think of them as risk management tools. A well-drafted contract isn't just a record of what you've agreed. It's the framework that protects your revenue and your reputation. I once advised a client who had relied on a handshake deal with a long-standing customer. Things were fine for a few months until the client started pushing for extra work without paying extra. My client had no written scope, no payment terms, nothing to fall back on. They ended up losing tens of thousands of pounds. That's why clarity up front is absolutely essential, and all of this could have been prevented with a well-drafted contract. So the first thing we want to think about is the scope of work. Be very clear on what you are delivering and equally clear on what you are not, which is sometimes just as important. Avoid vague language like consulting services as agreed. Instead, break it down. Specific services, deliverables, timelines, and milestones. And make sure you include a mechanism for change. If the client wants something outside of the original scope, have a process for agreeing extra fees and revised timescales. We call this a variation or change control clauses. Most disputes I see arise because one party thought something was included and the other thought it wasn't. The clearer you are in writing, the fewer arguments you'll face later on. The second point is payment terms. Cash flow is the lifeblood of every single business. Spell out how much you'll be paid, when it's due, and what happens if payment is late. Consider asking for deposits or stage payments, especially on larger projects. This keeps you from bankrolling your client's work. You can also have statutory rights under the Late Payment of Commercial Debts Act, but you can and should build your own late payment terms into the contract, including interest, or even the right to suspend work if your invoices aren't paid on time. I had one client who delivered an entire project only to wait 90 days for payment. Their contract said nothing about due dates for invoices, so they had no leverage. Don't let that be you. The third point to consider is liability and indemnities. This is where you protect yourself if things go wrong. You want to cap your liability, usually at the fees you've been paid in the last 12 months. That way you're not on the hook for unlimited losses if things go wrong. Exclude indirect or consequential losses like loss of profits where possible. Be careful with indemnities as well. An indemnity is a promise to cover someone else's losses. They can sound harmless, but they're often uncapped and they're an easier way to be sued. If a client asks for an indemnity, make sure it's limited to very specific, narrow situations that you can actually control. Think of it like insurance. You wouldn't agree to insure somebody's entire business without knowing the risks. Don't do it in your contracts either. The fourth point is intellectual property. For many businesses, this is your crown jewel. If you're delivering software, designs, content, or training materials, be crystal clear about who owns them. The usual approach is that you, as the supplier, keep ownership of your background IP and license it to the client. For bespoke deliverables, you can agree that ownership transfers, but only after full payment has been made. I once worked with a software developer who almost lost rights to his entire platform because the client's template contract said, all IP created shall vest in the client. Luckily, we caught that before it was signed. Always check your IP clauses before signing. The fifth point is termination. Contracts don't always run smoothly. You need a clear exit strategy. Cover the basics: termination for breach, insolvency, or persistent non-payment. Then decide if either side can terminate for convenience without notice. Say 30 days or 60 days, whatever makes sense in your business relationship. Also spell out what happens on termination. Are outstanding fees immediately due? Does data need to be returned or deleted? Can the client poach your staff or are they restricted? A good termination clause keeps things professional even when the relationship ends. The sixth point is confidentiality and data protection. Almost every contract should include a confidentiality clause. These protect your trade secrets, pricing, and client information. If you're handling personal data, you will also need to deal with GDPR. That means spelling out whether you're a data controller or a processor, what security measures you'll use, and what happens if there's a data breach. I've seen SMEs fined and embarrassed because they copied a template contract and forgot to address data protection. Don't cut corners on this one. And then the last and seventh point that I'm going to discuss today is dispute resolution. Choose the law and the courts that apply. For UK businesses, it makes sense to stick to England and Wales or to Scotland, not a foreign court where you'll need overseas lawyers if something goes wrong. You can also agree to mediation or arbitration instead of going to court or beforehand. These processes can be quicker and cheaper, but make sure you know what you're signing up to. Let's talk about negotiation and negotiation strategies. Start with your template, not the client's if you can. If you must use theirs, go through it line by line. Decide your red lines versus your nice to haves. Don't give away liability caps just to speed things up. Trade concessions strategically. And don't fall into the trap of over-negotiating minor points. I once saw a very important deal fall through because the supplier argued for weeks over formatting of invoices, but ignoring a liability clause that could have really sunk the company. Focus on what really matters when it comes to contract negotiations. Now, here are some of the common pitfalls and mistakes that I see. Copy and pasting internet templates that don't fit your business. Assuming a contract is standard just because the other side says so. Ignoring auto-renewal clauses that tie you in for years if you forget to give notice on time. And worst of all, signing contracts that don't match how you actually deliver your services. If your operations team works one way but your contract says something else, you're just asking for trouble. So here's a practical checklist that I want you to think about when you're signing up to a new contract. Before you sign, run through this quick health check. Number 1, is the scope clear? Number 2, are payment terms workable? Number 3, is liability capped? Number 4, who owns the IP? Number 5, how can you exit if needed? Number 6, is confidentiality and data protection covered? And number 7, do you know which law and courts will apply? If you can confidently tick off all 7, you will be in a much stronger position when it comes to your contracts. To wrap up, contracts aren't just legal formalities. They're business tools that protect your money, your reputation, and your future. Don't wait until a dispute arises to test your contracts, because by then it's too late. If you found this video helpful, please give it a thumbs up, subscribe for more practical legal insights, and leave a comment with your questions or experiences. And if your business needs tailored legal advice, my contact details are in the description below. Thanks for watching, and I'll see you in the next video.